Barnes and Barnes versus, is it Cerise Christian and Dylan Rose.
Illustrated for the plaintiff.
Before this hearing even begins, it is important to understand that this is not a dramatic criminal trial. It is a civil housing dispute where timing and paperwork can completely change the outcome. One missed signature, one misunderstood document, or one missed payment deadline can turn what looks like a resolved case into a judgment that follows someone for years. Judge Simpson immediately focuses on the facts instead of assumptions, and that approach becomes a recurring theme throughout this docket. Notice how neither side is accused of acting in bad faith right away. Instead, the judge carefully separates miscommunication from legal responsibility. That distinction matters because courts prefer voluntary compliance whenever possible before resorting to stronger enforcement tools. As this hearing unfolds, you will also notice that Judge Simpson consistently explains his decisions in plain language. Rather than relying on confusing legal terminology, he makes sure everyone understands exactly what will happen next and what the consequences will be if deadlines are missed. That approach not only protects the integrity of the court, but also reduces the chances that someone later claims they misunderstood the order. Another interesting pattern you will see throughout today's proceedings is how many of these cases revolve around communication breakdowns. Payments are made but not recorded. Paperwork is sent but never received. Repairs are promised but delayed, and assistance applications remain pending. Each situation sounds different on the surface, yet they all raise the same question. When disagreements arise, what evidence actually proves the truth?
Okay. Your name?
Dylan Rose.
All right. And where are we on this case?
I signed a conditional dismissal with Barnes and Barnes and agreed to pay the amount by the 19th.
That's partly correct. We sent him a COD and before I had a chance to look at it, it didn't have the immediate writ along with the judgment language in it. We sent it back to him and he didn't sign it.
I didn't know. I didn't realize I had another.
You had another.
I signed a document. They told me everything was fine last I spoke to them.
But did you get the second document?
I didn't get the second document.
You're saying you didn't get the second one, Mr. Friedman.
Okay, well.
Well, you're gonna pay it by the 19th.
Yes.
The whole balance.
Yes.
Okay. So here's what I will do. Partially because it's more beneficial to you.
Okay.
If you get it paid by the 19th,
Mm-hmm.
then the case will remain closed.
Okay.
Dismissed.
Okay.
You don't pay it by the 19th, then I will sign a judgment with a writ date as though it had happened today. So you'd have like 3 dates to get it paid.
Understood.
Okay.
Yep.
You understand what I'm doing?
I understand.
You follow that, Mr. Friedman?
Sure do.
This is a textbook example of a judge creating a final opportunity without rewarding delay. Judge Simpson is not canceling the debt or overlooking the agreement. Instead, he is preserving the original consequences while allowing the defendant one last chance to fulfill the payment commitment. That distinction is extremely important because a conditional dismissal is exactly what it sounds like. It remains conditional until every required obligation has been completed. If the payment arrives on time, the case ends cleanly. If it does not, the judgment proceeds almost automatically without forcing everyone to repeat the same arguments. That saves court resources while keeping both parties accountable. Notice how the judge repeatedly confirms that everyone understands the arrangement before moving on. Those confirmations become part of the record and reduce future disputes over misunderstandings. Do you think this was a fair compromise, or should the court have required immediate enforcement instead?
All right. And so they'll send you the copy of the COD if it comes in.
Okay.
That's fine, but we'll do it that way. Okay.
Okay.
All right. So I'll mark this conditionally dismiss, order to follow. But if not, judgment will enter with the writ date of the 22nd. Okay.
Understood.
All right. Very good.
Thank you.
Thank you. Arbor Woods versus Leticia Johnson. And is there somebody else? There is. Adrian Johnson. Oh, but I know I did that. Go ahead, Ms. Smith.
Good afternoon, Your Honor. Casey Matson, P87729 on behalf of plaintiff.
No matter, Ms. Matson, no matter what anybody said, I did not throw you under the bus. All right, I'm just letting you know. It was not me. Anyway,
Thank you, Your Honor.
the only reason I didn't mention Adrian is Adrian. Anyway, your names.
Leticia and Leticia.
All right. Okay, where are we on this case?
Your Honor,
Go ahead, Ms. Matson.
Your Honor, I have a total balance of $2,860.68. There should be somebody over there today to take care of the remaining repairs on the ceiling and the ceiling for the
So
ceiling.
that amount that you had was 28.
2860.68, and that includes the court costs of $242.
Got it. All right.
I put 500 on it today, actually, right before we came.
Do you see a $500 payment today or?
I do not have receipt of that today. The last one I have is from the 8th.
All right. And the repairs you say are going to be done today?
Yes,
The
Your
final
Honor.
on that? Okay. Is that your understanding also, folks?
Yes.
All right. Have you figured out how you're going to get the remaining part of this balance paid or?
Well, we've just been paying on this slowly. I think by the end of the month, we should have most of it about done. We still got a couple more checks before the end of the month.
Yep.
Okay. So here's what I'll do because the repairs have to be completed and I want to check on that. I'll adjourn this out to the 19th, 2025 at 1 p.m. for another in-person hearing.
Okay.
All right. We'll check the status of the repairs. And I suggest to you that you pay as much as you possibly can.
This hearing demonstrates that housing disputes are rarely just about unpaid rent. Here, repairs to the property are also influencing the court's decision, which means both financial obligations and maintenance responsibilities are being considered together. Judge Simpson refuses to rush toward a final ruling while important repair issues remain unresolved. Instead, he schedules another hearing so he can verify that the promised work has actually been completed. That protects both sides. If repairs remain unfinished, the tenant's concerns stay relevant. If the repairs are completed and payments continue, the parties move closer to resolving the dispute without further litigation. The judge also encourages continued payments before the next hearing, showing that steady progress often carries more weight than empty promises. Small, consistent payments can demonstrate good faith to the court even when someone cannot immediately pay the entire balance. Would you continue making partial payments in this situation or wait until everything was fixed first?
And then we can see where we go from there.
All right.
Sound good?
Sounds good.
All right. Folks, have a great weekend.
Thank you.
Thank you, Your Honor.
Thank you. Court calls the case of Arbor Woods versus Tisha Thompson.
Hello,
Hello, what's
I'm
your name?
Tisa Thompson.
All right. And where are we on her case?
Okay, I made the $2,000 payment as agreed last Friday after I seen you. I applied to DHS. I have an appointment with them today between 1:45 and 3:45. I have an appointment with Hawk on September 17th, I believe at 10 a.m. And I mean, I can enter into a payment plan, like I return to work next week.
Hold on a moment.
Sorry.
Did you get the $2,000 payment? What
Yes,
is
Your Honor.
plaintiff's back? What do you have as her balance?
We have rent to retain of $3,401.19, costs of $186 for a total of $3,587.19. So we did receive that $2,000 payment.
Got it. And your SER application is still pending at this point because you got to meet with them today, correct?
Correct.
And I think I did get the form in to the court. Yes, I think I got the rental assistance form in. So she'd be entitled to another adjournment. Let me ask this, ma'am. How much do you think between now and next week you can pay?
Nothing,
Nothing?
correct?
Okay, all right. So I'll adjourn this to the 19th, 2025 at 1 p.m.
Okay,
Okay, another in-person hearing. We, at that time, hopefully we'll be able to see what SER says and what Hawk says. I would just apprise you of this, and that is if Hawk has money, and I don't know where they are, it's pretty strapped at this point. You would have to come up with about $600 to get it down to what their maximum would be.
This exchange highlights an important reality about rental assistance programs that many people do not realize until they are already facing eviction. Assistance agencies often have funding limits, meaning they may cover only part of a balance rather than the entire amount owed. Judge Simpson is making sure the tenant understands that receiving assistance is not automatic, nor does it erase every financial obligation. By explaining the approximate $600 gap, he is helping her prepare instead of allowing false hope to build. That level of transparency gives people a realistic chance to make informed decisions before returning to court. Notice that the judge also asks how much she can realistically pay before the next hearing. Honest answers matter more than unrealistic promises, because courts generally value credibility over optimism. If you were in this position, would you borrow money to bridge the gap or wait and hope additional assistance became available?
okay,
That makes sense to you, what I just, okay? So you're facing that, you got SER and whatever, but we'll see where you are next week.
okay,
Okay?
okay, thank you.
Thank you.
What time am I supposed to come to, next, on the 19th?
1 o'clock.
Thank you.
You're welcome.
Have a great day, everybody.
You do the same. Arbor Woods versus James Lester III. And Yolanda Lester. Hello, state your name.
You good?
James Lester.
Yolanda Lester.
Thank you. All right. And where are we on this case at this point?
So, Your Honor, we were able to resolve the issues with the misapplied money orders. Those have been applied. At this time, the late fees have been removed and the month-to-month charges that were incorrectly applied to the ledger have also been removed. So there's just a small balance remaining. It's $58.59.
Did you say $8.59?
$58. And
Oh, 58. Okay, I thought you said $8. Okay.
That is for water and sewage. I'm sorry.
Okay.
I have a money order for it right here.
I don't doubt that. She has the money to pay it. So here's what I'm gonna do. You're gonna take that over to the office.
Oh, absolutely.
Miss Lester, I don't doubt that you're gonna do everything you tell me. From the last year, I just said, I don't wanna make a rant. That's been your life, hasn't it? Yeah, okay.
And I would like to say that, you know what, we tried to rectify this with the office there because we own this home since
Yes, sir.
2019. I've never missed a payment. We always pay early. They keep switching property managers, so we release the property.
No, I remember you saying.
Yeah,
this.
and every time they do it, something comes up.
No, I got you, but
And, you know,
I'm on it.
I'm sick. This
What's
is
that?
this almost, you know, it caused rift between our marriage. I had to go to the VA hospital for 2 days because it stressed me out. You know, I'm telling them I paid them. We have receipts. They tell them that we didn't.
We passed all that. It's all done. I have a
but you're
question
still
though.
married.
Yeah.
Okay, see? So it wasn't that bad. All right.
I have a question.
Yes.
Is there any way we can guarantee that the sheriff is not going to come knocking on my door? Because
Because
this situation
you know what?
evolved into,
I will give you the guarantee because they don't come until they have a judgment or something else and I sign an order directing the sheriff to be there. I'm not gonna sign that order because Ms. Lester, you're telling me you have the $58 change. You're gonna
absolutely.
pay that. I believe that that's what you're gonna do. And so at that point, and the reason I'm putting it out to the 19th is that once that's paid, they're gonna submit a dismissal and the case is done. So nobody's coming knocking at your door. You guys are.
Okay, I do have one other question.
I knew you would.
When I spoke to her this morning, she mentioned something about attorney fees. Has that been waived?
Just when this case appears completely resolved, another issue suddenly surfaces: attorney fees and court costs. This is a reminder that paying overdue rent does not always end a legal dispute. Additional costs can remain, and someone still has to decide who should be responsible for them. What makes this situation especially interesting is that the tenants argue the confusion resulted from accounting errors rather than their own failure to pay. Judge Simpson refuses to make a snap decision. Instead, he wants the landlord's representatives to determine whether those additional charges should still be pursued before he rules. That cautious approach protects the integrity of the process because it prevents someone from being unfairly charged without a complete review. The judge is also separating the emotional frustration from the legal question that remains unresolved. Sometimes the hardest part of judging is slowing everyone down long enough to make the right decision instead of the quickest one.
Because we don't feel we should be responsible for attorney fees for something that should not have. I mean, it's been a pleasure speaking to you, and meeting you, but we could have done it under different circumstances.
Okay, hold on a second. Counsel, I don't know the answer to that.
Yes, Your Honor, the rent to retain is $58.59. The court costs are $242. So there's a total of $300.59. We are working to see if we can do something about those court costs. So we were going to request an adjournment to the 19th.
Got it. Does that make sense to you? No, does it?
It'll register later.
Pardon?
It'll register.
Let me just say, here's what.
We've got to come back here on
Let me break it down for you.
Okay.
So you've got to go pay the 58.
Mm-hmm.
Because of everything, they're going to check, no guarantees at this point. They're going to go check as to whether or not what they're going to do with those attorney fees and court costs because of what had happened. Same thing that you're saying.
Right.
They don't, as I understand it, they don't have the answer for their client yet.
Okay.
Okay. You disagree with it. If their client comes back and they want that paid, then the decision becomes mine.
It becomes another bad issue.
Well, no, it just becomes, I make the decision.
Okay.
Yeah.
Okay.
Yeah. We didn't do anything wrong. Paid our rent early or on time.
We've been good people.
6 years.
Okay. So can we come back on
Not doubt that. You need to come back on the 19th.
On the
at
19th?
1 o'clock.
at 1 o'clock?
Yes, sir.
Yes, sir.
Okay.
Okay.
Will that work?
Yes, and I'm going to pay this on the way in.
Okay. Thank you very much. And Mr. Lester, I want to say
Thank you.
something to you. I wish that there had been a lot of young men in this courtroom and watched how you treated your wife.
Moments like this are one reason Judge Simpson's courtroom stands out. After spending the hearing discussing rent balances, accounting mistakes, and legal procedure, he pauses to recognize something completely different: simple respect between two people. The judge noticed details that many viewers might have overlooked, including Mr. Lester making sure his wife walked through the doorway first and supporting her throughout the hearing. Legally, those actions have nothing to do with the outcome of the case, yet they reveal character in a way paperwork never can. It also reminds everyone watching that judges observe far more than testimony. They watch attitudes, patience, courtesy, and credibility from the moment people enter the courtroom until they leave. That brief compliment changes the emotional tone of the hearing and offers a rare positive moment in a day filled with financial stress. Sometimes a few sincere words from the bench can leave a lasting impression long after the legal issues are resolved.
All right, because
34
You got-
years, 34 years.
yeah, but nothing got lost because when you got up and you got the walker there, when you got up, she got up, but you made sure she went through that door first. And you just backed up, and I have to say, I appreciate seeing that. Okay?
Thank
Guys
you,
have a
Your Honor.
blessed weekend.
Thank you.
Thank you. We'll see you next.
Yes. Ma'am. Arbor Woods versus Lisa Thompson.
Lisa Thompson.
Oh, she's on the, got it. Okay, what does plaintiff have?
Your Honor, I have rent to retain of $3,264.44, costs of $186 for a total of $3,450.44. And we would be asking for a judgment today.
Ms. Thompson?
Yes,
Ms. Thompson,
yes.
how are you gonna get that paid?
Sir, I don't get paid until the 15th. I was literally going to give at least between $500 to $700, and then I don't get paid again to the 29th.
But ma'am, and how much were you gonna give on the 29th?
I was going to have the remainder balance.
Have you tried to work out something with the landlord, ma'am?
I've called the lawyer's office as well, and I have not received a phone call back. I left messages.
I'm gonna issue a judgment finding no tribal issue after a hearing in this matter. Ma'am, what day do you get paid?
I get paid the 15th, and then I get paid the 29th.
You get paid on Monday?
Yes, sir, I do.
I'll issue the judgment in that full amount of the 3450.44. The writ date would normally be the 22nd. I'll extend it out a week to the 29th. You need to go in and pay that money. I'm not making it part of this. I'm giving you that extra week, but ma'am, you need to work something out with your landlord. But if it's not in there, I'm signing the writ.
Judge Simpson is sending a very clear message here. Extra time is an opportunity, not a guarantee. Instead of allowing the standard enforcement timeline to move forward immediately, he voluntarily extends the writ date by 1 additional week. That may not sound significant, but legally it gives the tenant valuable time to negotiate, make payments, or reach an agreement before stronger enforcement measures begin. At the same time, notice that the judge refuses to become the negotiator between the parties. He repeatedly directs the tenant to communicate with the landlord's attorneys because that is where a payment arrangement must ultimately be reached. Courts can create opportunities, but they cannot force private parties to settle outside the courtroom. This ruling strikes a balance between compassion and accountability. The deadline has been extended, but the responsibility has not changed. If you were given one final week like this, how would you use it to avoid a judgment?
So do I need to go to the office or continue to call the lawyer's office?
To pay the money, you probably need to go to the
No,
office.
to work something out with the landlord.
You're gonna have to work it through their attorneys. You can also talk to the people in the office, but you've got to the
Okay.
29th to get all of this paid.
No, sir. No problem, sir.
Thank you.
Thank you. Have a great weekend.
You too. Arbor Woods versus Mary Clark. Okay, we'll wait for you.
Hello, Your Honor.
Hello, what's your name?
Mary D. Clark.
All right. And what is plaintiff's claim in this case?
Your Honor, I have rent to retain of $1,141.83, costs of $186 for a total of $1,327.83.
All right. All right, Miss Clark,
Yes.
how are you intending on getting that paid?
Well, I don't owe it for one thing. I paid all my rent and my water bill. I don't understand what's happening. I really don't. I paid September already
When did you pay September?
on the 2nd or the 3rd.
Okay.
Your Honor, I do have
Yes, go ahead, Counsel.
I do have a payment on September 3rd for $751.78.
Okay. Where does it look like this balance? I realize it could fee for a number of things, but where does it seem to derive from, council?
It appears there were payments in September, August, July. Oh, Your Honor, it appears that NSF, there was an insufficient funds from the August payment. That combined with an accumulation of small balances over time.
Gotcha. Okay, do you have your, how do you pay?
My credit union, people
Okay,
driven.
no, I got you, but is it by
Okay.
check?
Pardon?
Is it
No,
by
it's
check?
a money order. I
Oh,
don't get the, what do you say? I'm a little
No,
discombobulated
it's
right
okay.
now,
you-
but I pay by money order
Gotcha.
and it's in before the 5th of every month. May, June,
Okay, no,
July.
okay, so somewhere you've accumulated some fees, and we can deal with that, but the big thing seems to be your August payment was
I paid it.
NSF.
I paid,
I'm not sure how that happens with the money order.
I'm not either. No problem with the rest of them.
I know,
Uh-huh.
I got you. I'm
Got
just
me?
trying to,
Okay. I don't understand.
do they, Ms. Mattson, does it show no payment or does it show a payment and then it was reversed out?
Your Honor, it
That's a-
does show a payment and then it came back as NSF. I'm not entirely sure reason that it came back. If defendant has some sort of proof that it did come out of their account.
Okay, do you? So when you go get a money, when you go to the credit union to get your money order,
Mm-hmm.
right? And they take that right out of your account? Is that how they
Yes.
do it?
Oh, they don't take it right out of my account. No.
Okay.
I get a money order and take it into them.
No, I'm talking about the credit union.
Oh, the
So
credit
when you
union?
go in, you say, I need a
Right.
money order,
Mm-hmm.
and you're not coming in with money. They just take it out of your account and
That's
give you a money order,
correct.
right?
That's correct.
Okay, so when do you normally do that in the month?
Before the 5th of every month.
Okay,
Mm.
so you go to the credit union before the 5th of every month, and this is what you do.
This is when my checks
Okay.
come in. Yes.
So do you have, who's that with you?
This is my niece, Marcia
Hello, Mark.
Presley,
All right.
and she's been helping me a lot.
No, I see that. Who's the other one that's a big helper?
Great grand and great niece.
Great grand.
Mhm.
Great grand.
Oh, look at you. You are cute. What's your name? Hi.
Tell them your name.
What's your name?
Michaela?
Montasia.
Montasia. That's beautiful.
Mhm.
Thank you.
All right. Do you have, I see you have a stack of papers. Do you by chance have something that indicates that came out of her account in August?
From the bank.
Yeah. I don't know if you have that or not. And if you did, that'd be great, but
No, but we could certainly get it.
right, that's okay. So here's what I'll do. Because I'm not sure. I'll adjourn it to September 19th, 2025 at 1 o'clock. Okay, because the one thing I'm not sure about is how they get a money order. It goes in, then goes out, back out NSF,
When,
because it should have been honored.
if I may, when we went in and spoke with someone in the office, they said it was a mistake and that they would fix it and they were supposed to call her back and she never heard from.
Okay, so
And
that's an important fact. So you went in, talked to somebody in the office, they said it was a mistake. What part was a mistake?
The insufficient funds,
Got it.
first of all, and so that would be, I don't have.
For August
I don't have exactly.
I have a August receipt here.
Yeah,
from them? Okay, it would, because you would have gone in, paid it, but they're saying that whatever your form of payment is came back. I'm not sure how that happened.
I don't understand.
And then if you're saying you went into the office, they told you that, council's probably gonna want to check on that, because I don't know how a money order comes back NSF. I mean, I guess it could theoretically.
This suddenly becomes one of the most interesting cases on today's docket, because the evidence no longer points in only one direction. The tenant insists she paid with money orders every month, the landlord's records show an NSF reversal, and now there is testimony that someone in the leasing office allegedly admitted it was a mistake. Rather than choosing a side based on assumptions, Judge Simpson does exactly what judges are supposed to do. He asks for documentation. Bank statements, payment history, and internal records are all far more persuasive than competing memories. His confusion about how a money order could be returned for insufficient funds is understandable because money orders generally function differently from personal checks. Instead of making an immediate ruling, he creates time for both parties to verify the facts. That protects everyone involved and increases the likelihood that the final decision will be based on evidence rather than speculation or misunderstanding.
So here's what I'm gonna need from you. I've adjourned it out 1 week. And I'm gonna need, and why don't we go back to, say, June? And just get your bank statement showing, so that I can see it showing that you've taken that money out each month. Okay?
Do we have them?
I'm not with.
It's on my receipts. I don't know.
No, I know what he's asking for.
Okay, I'm all discombobulated.
We'll get it.
No, you're good. Okay, somebody's here with you. We'll get it. We'll figure it out. I just want to take a look back. You make that payment, and then at the same time, I'd ask council to check if it was a money order, how it was NSF, whatever it was, a mistake.
Okay,
Okay?
all right.
Is that okay? You still discombobulated?
Yeah,
Okay, me too. Don't worry about
are you? Well, we,
it. We can be that way together.
yeah,
All right.
thank
You
you.
take care.
You too,
Thank
thank
you.
you.
Bye-bye, little one.
Say goodbye.
Bye.
Today's docket demonstrated that many housing disputes are not simply about unpaid rent. Several cases involved paperwork errors, delayed repairs, rental assistance applications, accounting discrepancies, and communication failures between tenants, landlords, and property managers. Throughout each hearing, Judge Simpson consistently focused on documentation, realistic payment plans, and ensuring every party clearly understood the court's orders before leaving the courtroom. In some cases, he granted additional time, while in others, he entered judgments or established firm deadlines, always balancing fairness with accountability. The biggest lesson from these proceedings is that good records, prompt communication, and honest efforts to resolve disputes often carry significant weight in court. Missing deadlines or failing to provide documentation can quickly change the outcome of a case, even when someone believes they are in the right. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.